Ms. Milito.
Thank you. My name is Elizabeth Milito. I'm here today on behalf of the National Federation of Independent Business. NFIB is the nation's leading small business advocacy organization with a national membership of 350,000 independently owned and operated businesses. While there is no standard definition of small business, the typical NFIB member employs 10 people and reports gross sales of about $500,000 a year. NFIB's membership is a reflection of American small business. Currently, small businesses in this country employ nearly half of all private sector employees. Small businesses pay 42% of total U.S. private payroll. Small businesses generated 63% of net new jobs over the past 20 years. And since the end of the recession, small businesses have accounted for 60% of new jobs created. In summary, small businesses are America's largest private employer. For this reason, it's critically important that the board understands small firms' unique business structure and the exceptional problems that the board's proposed amendments to its election rules would place on the smallest, but arguably most important employers in this country. Small businesses face unique challenges that make compliance with the NLRA exceedingly difficult for even the most determined small business owner. In many small businesses, employment concerns, including issues related to labor matters, are made by the owners of the business, who upon receipt of an election petition wouldn't have a clue what to do and would not only need to consult with an outside advisor, they would first need to find such an advisor with whom to consult. For this reason, NFIB is very concerned about limiting the scope of pre-election hearing issues. The NPRM would limit the pre-election hearing to determine only whether a question concerning representation exists. This means that many issues of voter eligibility, including supervisor status, would be deferred to post-election procedures. As a result, employees would vote in an election without knowing which employees will ultimately make up the bargaining unit. And some employees who vote might be found ineligible to be part of the bargaining unit. For small businesses, however, deferral of issues essentially means waiver and defeat. A small business simply cannot afford ongoing litigation and legal fees. To ensure due process in representation cases, Congress amended Section 9 requiring the board to investigate each petition, provide an appropriate hearing upon due notice, and decide the unit appropriate. Should the board proceed with its proposed rule, NFIB believes that employee-informed choice and due process notice and hearing required by Section 9 will be compromised, particularly for small employers lacking labor relations expertise and in-house legal departments. And I will also add, too, I know the board has posed a question relating to whether or how the NLRB could provide assistance to unrepresented small businesses in complying with election procedures. I'm happy to address that issue now, or if you'd like at a later time.
Well, I think we better stick with the topic at hand.
Okay.
Okay. Now, wouldn't you agree, Ms. Milito, that if you're talking about a small business, you're usually talking about a small bargaining unit, and that the 20% rule would apply to a smaller number of people? When you say so?
Yes, okay. That's obviously true. Yes.
Yeah. So in terms of the frequency of the utilization of that 20% rule, the size would impact how frequent that would be used. I would imagine. Mm-hmm. But that being said, when you have the ability to defer an issue until after the election, many an issue becomes mooted out, and it may not be necessary to litigate it. Certainly, if a client reported back that they had the election and the union lost, the issue of supervisory status becomes a moot issue, and that would resolve a lot of costs on the part of the employer in litigating that point. Wouldn't you agree?
I would agree that the issue would be mooted out for a lot of small businesses, because I think it's just a matter of they're going to throw up their hands, and as I said in my testimony, I mean, really it's going to be concede defeat. I mean, I think Mr. Deacons pointed out very ably how, you know, if you have in a small business, you may have a manager who's clearly outside the bargaining unit maybe, but maybe an assistant manager. Is that individual in or out? And that could make a difference for the remaining 5 or 6 employees. So it is an important issue for that small business, and is one that should be resolved at the outset, because it could impact the decision of the other, you know, as you pointed out, 5 to 6 employees, and in other words, impact the entire business ultimately.
Right, and that's a decision that really wouldn't have to be made if the union didn't win the election.
If the union didn't win the election, you're saying?
Right.
If they didn't win the election. But if they did win the election,
then the employer has the opportunity to litigate it.
And my point is, a small business owner is not going to litigate things post-election. It's just not going to happen. I've seen that firsthand. They're not going to have the resources, the money, the time to continue litigation. They will already have spent however much money retaining counsel to see them through, you know, the election.
Okay.
If your average size is 10 members of the employees of employers in your organization, and we have a 20% rule, and we're talking about that one assistant manager, is even if we're awaiting the election results, is it important or unimportant to your members to know whether they can communicate or utilize that manager as their representative in the ongoing campaign?
It's critically important. I mean, it's critically important to know. I mean, there's only, you know, the only other mouthpiece is likely the business owner too, and the manager is probably the first line, you know, the first line kind of, you know, interface, if you will. And so that's why, or the assistant manager, if there's a manager and assistant manager. So I think it's critically important to have those issues resolved, and it can make a huge difference for a small business owner to know that it's not just them, but they have the support of this person who they saw as a manager.
Now, I'm going to engage in some incredible flattery here, so excuse me. We sort of have the creme de la creme of the management side bar that comes to these things and presents, and they talk about their best practices and whatnot. Typically, do your members, the counsel that they hire for litigation of any form, are they generally tend to be members of this august group or not?
No. And I say that with much respect. Yes, yeah. And I will give you a real life example. I had a call from a member last summer who received, it was a ULP, it was not an election petition. He had called his attorney, and that's what he said to me on the phone. I called my attorney. And you know what my attorney told me? I don't do that kind of stuff. This was from a little town, small town in Indiana. And he said, and I said, well, who should I call? And my attorney told me, I haven't a clue. I don't know anyone that does that stuff. So it is sometimes, you know, and ultimately he did find somebody, but it did take several days. So it's just finding a labor attorney that can be difficult and can take some time.
I just have an observation without any disrespect to people not here. I think this august group also includes the creme de la creme of the union side bar as well.
Of course.
But I just want to express that observation.
I would join that statement.
Yes, that's very. And if I could just add too, just because there are attorneys not in this room, there are absolutely fantastic labor attorneys on both sides throughout the country. And, you know, it's just a matter of finding them, because it's not, you know, you have more attorneys that do family law or criminal law, or, you know, he set up my corporation, but, you know, I don't do that kind of, you know, labor stuff. It is a specialized area field.